Binger's performance at the preliminary hearing to establish probable cause for this case to go to trial was one of the most embarrassing moments I've ever seen of a lawyer. You may remember in Las Vegas, one of the lawyers got drunk and tried to fabricate some sort of crazy story, and the judge caught him on it and basically made him take a breathalyzer test. I think that Binger's performance is almost as bad. And quite frankly, I think I'd rather have that other lawyer from Las Vegas on my team than Binger. However, this may have lulled Mark Richards and his team into a false sense of security. Binger's not the only lawyer working on that case. And they may have a counter-argument prepared for the motion to dismiss the minor in possession charge. As far as I can tell, July 1st is the last day that they can file such a motion. And my concern is that they haven't put all their ducks in a row here. There is a subsection of the Wisconsin statutes that everybody has ignored, but I think is quite relevant for establishing whether Kyle needed a certificate of accomplishment to possess his rifle in Wisconsin. I run the risk here of broaching the Dunning-Kruger effect, which basically happens when somebody learns a little bit about a subject and thinks they're an expert. And I'm an engineer. I get this all the time. Some people come to me with some of these crazy technology ideas. A lot of them violate like the second law of thermodynamics or law of conservation of energy or things like that. In other words, perpetual motion machines. And what's happened is they've learned a little bit of science, and then now they think they're real experts on it. And I run the risk of doing that here in law. However, I don't care. I'm going to go ahead and put this together. I'm going to formulate an argument that I think settles that Kyle is not guilty of minor possession. And I'm just going to put it out there. So, you know what? If they want to gather around and have a good laugh about how idiotic I am about the law, fine. I don't care. I got nothing to lose. However, I would like the defense team to see this. I don't know how to get it in front of them, to be honest with you. I could file an amicus brief as a friend of the court, but I think you have to be invited to do that. And I'm not a lawyer, so they probably wouldn't even accept it anyway. So if anybody knows how to get this in front of Kyle's team, by all means, let me know. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, 948.60, possession of a dangerous weapon by a person under 18. This is the one that Binger has charged Kyle with. We're going to walk through this very carefully. Subsection 1 defines a dangerous weapon. Fine. The AR-15 is a dangerous weapon, no doubt about it. Right, Gage? Subsection 2. Any person under 18 who possesses a dangerous weapon is guilty of a Class A misdemeanor. All right, that's the one that got Binger all excited, and that's the one that he has charged Kyle with, and apparently he didn't read anything beyond that. Subsections B through D do not apply to Kyle's situation at all. Now, subsection 3 is where things get mighty interesting. Kyle is not guilty if the gun is used for target practice. I grayed it out. We don't care. And also, he's not a soldier, so we don't worry about A and B. However, C, Kyle is guilty only if he is in violation of subsection 941.28 or he is not in compliance with both subsections 29.304 and 29.593. Okay. And by the way, I have colored red the Boolean operations. Those are really important to make sure you understand. Now, everyone agrees that Kyle is not in violation of subsection I. Okay. And by the way, I and well, actually 1 and 2 Roman numerals, those are things that I inserted. They're not actually in the actual statute. The text is, but I'm the one that broke it out into subsection Roman numeral 1 and Roman numeral 2. So I colored Roman numeral 1 in violation of section 941.28 because everybody agrees he is not in violation of that one. But what about these two? 29.304 and 29.593, the ones colored in purple and brown. Well, he has to be in compliance with both. So, what is 29.304? Restrictions on hunting and use of firearms by persons under the age of 16. Everyone agrees that 29.304 does not apply to Kyle. All right? Kyle is 17, not under 16. However, therein lies the problem. In fact, 29.304 does not apply to Kyle so clearly that it has led Kyle's defense to maybe overlook it. We'll get to that in a moment. What about 29.593? Well, that's a requirement for a certificate of accomplishment to obtain hunting approval. Now, this is where the defense and the prosecution are going to split their opinions. Well, Binger might not, because he may not get here. I mean, he's just going to go back to 948.60 and repeat it again, I guess. I will say this, man. He'd better do a better job in responding to this motion than he did back in November. The defense is going to claim that Kyle is in compliance with 29.593 because he was written specifically to address hunter safety. In other words, Kyle's not hunting, therefore he is in compliance with 29.593 because 29.593 does not apply to him. The prosecution is going to say that it does apply to Kyle regardless of whether he is hunting or not, because the hunter education program has a component in it that includes basic firearm safety. And so the prosecution is going to claim that Kyle's possession of a weapon would have required this certificate of accomplishment because it includes that firearm safety component. Now, let's take a look at it. I just want to make sure everybody understands I'm not making this stuff up. Okay, so here is a study guide for hunting education in Wisconsin. And if you look, Unit 1 has Introduction to Hunter Education, Firearm Safety Rules, the importance of hunter education. And then you go to Unit 2, Know Your Firearm Equipment. And what is a firearm? What is ammunition? Okay, boy, they start out at the most fundamental levels here. Okay, so one thing is clear. The hunter education program does cover firearm safety. And the prosecution is going to lean on that in their rebuttal. The defense has to be prepared. That's one of the things I learned about, being a lawyer in this, just looking around. I'm not a lawyer, but I'm just saying that in talking to lawyers and reading what they're saying, one of the things that came out was the importance of being able to predict what the opposition is going to say and being ready to oppose it. In the preliminary hearing, Binger was completely unprepared for Richards's motion to dismiss. The only thing that saved Binger's hide was the fact that the person conducting that hearing, which was Lauren Keating, he's only a commissioner. And I don't think a commissioner is going to want to interpret the law and dismiss charges in such an important case. I think he's going to want to go ahead and push that to the trial, which is exactly what he did. Contrary to what a lot of people think, Keating didn't shoot down Mark Richards' argument. He just didn't want to deal with it. And he said that he was just going to have to take it to Judge Schroeder. Judge Schroeder may not even want to deal with this thing. He may push this to an appeals court. That spells bad news for Dominick Black, because Dominick really needs to have this charge dismissed against Kyle Rittenhouse. The prosecution's going to claim, no, you got to have a certificate of accomplishment, regardless of whether you're hunting or you're possessing, because the certificate of accomplishment guarantees that you know how to operate a basic firearm. The defense is going to say, no, it was written specifically for hunting. If you're not going hunting, it's not necessary. Okay? And at that point, if that is the defense's only argument, they might lose this. And the reason why is because the state court system in Wisconsin is probably a little left-leaning, and they're going to want Kyle to be convicted here. And so they're going to be very amenable to the prosecution's argument. So if I'm Mark Richards, I'm going to be very careful and make sure that any kind of opposing argument I can shoot down. And in the rest of this video, I'm going to show you how he can do it. It comes down to this. What was the intention of subsection 29.593? That is, the requirement that one obtain a certificate of achievement to go hunting. And I'm going to go ahead and italicize this last comment here, because everyone assumed 29.304 did not apply to Kyle. They assumed it was irrelevant to deciding whether Kyle was in violation of 948.60. What's 948.60? Minor in possession. And by the way, I'm calling it minor in possession, but the actual Wisconsin statute talks about possession by someone ages under 18, and that's a whole nother video. Okay, so is Kyle guilty of minor in possession? Again, everybody assumed 29.304 had nothing to say about this. They were wrong. To understand the intent of 29.593, one must read 29.304. which states restrictions on hunting and use of firearms by persons under age 16. And I know what you're thinking. Wait a minute. Kyle is 17. This doesn't apply to him at all. You're wrong. It's quite relevant. You'll see. Hang on. We can forget the first two subsections and concentrate on subsection 3, persons 14 to 16. Subsection A, restrictions on hunting. No person aged 14 through 16 may hunt unless he or she is accompanied by his or her parent or guardian, is issued a certificate of accomplishment stating he or she has completed the course of instruction under the Hunter Education Program. Hunter Education Program. B, restrictions on possession or control of a firearm. No person aged 14 through 16 may possess a firearm unless he or she, 1, is accompanied by his or her parent or guardian or adult designee, same as for hunting, is enrolled in the course of instruction under the Hunter Education Program, and is carrying the firearm in a case and unloaded to and from that class, or is handling or operating the firearm during that class under the supervision of an instructor. Or 3, is issued a certificate of accomplishment. So, one thing that's important to understand here, Section 29.304 delineates between hunting and possessing. They have different requirements. They're very similar, but they are different. And therefore, the Wisconsin legislature clearly thinks that hunting and possessing should involve different requirements. Now we could go on down. Subsection 4 doesn't pertain to anything here. Neither does 5, and so on. I've grayed out also the history, but Kyle's lawyers will probably want to go through all that and check it out. That might create some clues as to the intentions of things, but I don't get paid for this. They do. They can do it. Now, let's take a look at 29.593. Requirement for a certificate of accomplishment to obtain hunting approval. Subsection 1. A. No one may obtain any approval authorizing hunting unless the person is issued a certificate of accomplishment. And I put a note in here. This is my note. No mention of authorizing the possession of a rifle. They only mention authorizing hunting. Okay, we don't have to worry about these next few subsections. Number 4, a person who is subject to subsection 1 may prove compliance with subsection 1 when submitting an application for an approval authorizing hunting by presenting any of the following. Okay, so subsection 4 goes, how do you show that you have met this requirement? A, his or her certificate of accomplishment issued under subsection 29.591. Well, what does that cover? We could take a look at it. 29.591, the Hunter Education Program and Bow Hunter Education Program. All right, if you want to cruise through this, you can, but you will notice everything in here is specific to hunting. It mentions nothing about firearm safety at all. And we notice that B and C talk about hunting. And C specifically refers to hunting season. All right. How does Wisconsin treat this possession versus hunting? For adults, open carrying of a rifle, which is an extreme form of possession, does not require a certificate of accomplishment. Hunting does. Doesn't matter how old you are. You could be 40 years old and a seasoned marksman, but you still have to have a certificate of accomplishment to go hunting. However, you could carry an AR-15 around town without having a certificate of accomplishment. That indicates that Wisconsin believes that hunting is inherently more dangerous than open carrying, and that the certificate of accomplishment is really targeting things related to hunting. You know, what kind of deer can you hunt? What's your limit? That kind of stuff. Yes, there's a component of firearm safety in it, but clearly the certificate of accomplishment is geared towards hunting issues. Okay, so what are the conclusions? Why would a person under 18 need a rifle? Well, hunting, target practice, self-defense, and freedom. And, you could also argue that, well, robbing a liquor store, sure. Going out to shoot somebody, sure. Going out to provoke people with your rifle, sure. But those are covered already under other statutes, and they're already crimes. So we're talking about here, why would a person legally need a rifle? Wisconsin clearly delineates between hunting and possessing. For children younger than 16, hunting and possessing are governed by different subsections in 29.304 and have different requirements. They're similar, but they're not the same. Adults can possess firearms in public, but cannot hunt without a certificate of accomplishment. Section 29.304 only provides stipulation on children up to age 16. It provides none on ages 16 through 17. 2. If the Wisconsin legislature wanted the certificate of accomplishment to address both hunting and possession, it could have expressed that sentiment in 29.593. It has not done so. The Wisconsin legislature could have mandated those ages 16 through 17 to obtain a certificate of accomplishment to possess a rifle. It has not done so. As such, it is clear that Section 29.593 was written purely for the purposes of hunting. It was not written for the purposes of establishing firearm safety. There is no evidence that Wisconsin law intends for those ages 16 through 17 to obtain a certificate of accomplishment to possess a rifle. Now, I do want to circle back on here. You might be thinking, well, wait a minute. Just because the Wisconsin legislature could have put something in the law but didn't do so, does that mean that you can interpret that as evidence that the legislature did not want it? The answer is yes. There is case law on this. Because the Wisconsin legislature could have easily mandated that a certificate of accomplishment was needed for a person of age 17 to possess a rifle and did not do so, then you can interpret that as indication that Wisconsin legislature had never any intention of doing so. Now, why would that be the case? Well, Wisconsin is a very rural state. It has some cities, sure, but it's largely rural. And therefore, children ages 16 through 17 probably possess rifles all the time. They carry them around, they go target practicing and such. The Wisconsin legislature never envisioned that these kids, 16 through 17, would carry the gun to a protest. And therefore, they probably never saw any reason to require a certificate of accomplishment for children ages 16 to 17. For hunting, they did, because hunting is inherently more dangerous. You're shooting at things, you can accidentally shoot somebody else, you can accidentally shoot yourself, but just simply possessing a rifle, carrying one around, is typically safer. And so it's pretty clear to me as to why Wisconsin didn't bother to tighten this thing down and require minors of age 16 through 17 to obtain such a certificate of accomplishment. Now remember, adults 18 and older are not required to obtain a certificate of accomplishment to possess a rifle. They are required to get one to go hunting. My concern was that Mark Richards and company were not going to take into account all of this. They were going to rely purely on 29.593 not applying to hunting and open themselves up for an easy counter argument from the state. However, if they are prepared and they can demonstrate that the Wisconsin legislature never intended a certificate of accomplishment for possession of a rifle for kids ages 16 through 17, they should be on solid ground. In my opinion, in looking over the expanse of all of this, Kyle legally possessed the rifle on that day in Kenosha. Like my video, subscribe to my channel.